A man accused of violent crimes, $1 million bond, and a judge who uncovers a criminal history that leaves the entire courtroom stunned. But when the defense asks for a bond reduction after 3 years behind bars, the hearing takes an unexpected turn. Watch closely, because every detail changes the stakes.
Controlled substance and was found guilty of that in 1990 in this court, criminal district court. After that was final, you committed the offense of illegal possession of a controlled substance, a third-degree felony in 2007, and were finally convicted of that. That was so you were a habitual criminal 2 convictions ago. So your bond is $250,000, and the circumstances here is that police on Friday, April 10th this year, were dispatched to Swift gas station 4705 Magnolia here in Beaumont, Jefferson County. Observed a black male laying on the sidewalk who had been shot. And police reviewed the store surveillance camera showing you shoot him, and you were detained, and they found you in the area, and you were Mirandized and agreed to speak to officers and admitted to shooting Caesar. You were then placed under arrest for aggravated assault. And when they searched you, was that cocaine found on them?
That's what it appears like, Judge. I'm checking. I don't see where we got.
And 2 firearms. You're a convicted felon already. As you know, you're unable to possess a firearm. It's not only a state crime, it's a federal crime as well. All right. It's $250,000. The bond is $250,000.
If I may, this happened or occurred at his residence. There's a question of whether or not he can have a firearm or not with reference to the possession on the state side. I understand the federal side. The instrument that was used that he admitted to was a BB gun. Yes. And when they found the complainant on in front of the convenience store, he was too intoxicated or high to even communicate, so they brought him to the hospital at that time. This had to do with an incident that
you said the defendant. You're talking about the victim.
The victim.
I'm not talking about the defendant.
Was already done. The victim was out in front of the convenience store. You know, it was a determination that he was too intoxicated or high. That's time. I questioned the indictment enough it's to a firearm. I don't believe the BB gun constitutes a firearm, though a BB gun could be a deadly weapon. It's not alleged that way. I'd ask that the bond be lowered. One, because it was not invalid. There was a complication between the complainant and Mr. Goodman, and he would not leave, and he was threatening him. And I know those are matters for trial. But we would ask that the bond be reasonable in light of these circumstances. And I believe possibly controlled substances were when they went inside the house and not on his person.
Anything else? For you, say.
Oh, Judge, I think we've got a good grasp of it. I would tell you that the reports don't state a BB gun. They do mention a pellet rifle. But the state feels that the specifically based upon his admissions and his criminal record that the county can only be safe if the bond continues at the amount that it's set.
Yeah.
Well, yeah, you're right. He's sitting on his front porch in his own house minding his own business. That's where it occurred. It didn't occur in the parking lot of the convenience.
That's just not what the probable cause affidavit states.
That's where he was.
The bond, the court feels that this bond is appropriate under these circumstances in your rich criminal history.
We'd have
That is
to
all.
place on.
All right. You're Jamal McCain. Okay. You're here with Mr. Barroso, your attorney and the state's attorney.
Yes, sir.
You're charged with 3 habitual felony crimes.
Yes, correct.
So you're looking at 3 times 25 years to life imprisonment, 3 times that. In 23 CR 795, third-degree felony of tampering or fabricating with evidence. You have 3 prior convictions in sequence, controlled substance, and evading arrest or detention of a motor vehicle. So you're looking at 25 to life on that. Unlawful possession of a firearm by a felon on April 18th of 2023, the same date as this earlier one. And the allegations are similar with the prior convictions. You're an habitual felon on that one. What's the date he was arrested on these 2? Anybody know?
I'm not sure, but I do know that he's been incarcerated for 3 years as of June, sometime first week of June, or the around there.
Well, how long have you been representing?
Well, I was appointed in February. I'm his 3rd attorney. His last attorney was Ryan Matuska, who we all understand has gone over to the federal.
I didn't know that.
Oh, I thought you were aware of that. Sorry. So he
Don't necessarily tell
2
me.
previous attorneys that withdrew. I'm his 3rd. I'm his 2nd appointed attorney. I believe the first one was hired, which was Marcus Wilkerson. He ended up withdrawing. Mr. Matuska was appointed. He ended up withdrawing, and then I was appointed. And from my understanding, this is the first time that Mr. McCain has been before the court on asking for a bond reduction. And he's been there for over 3 years.
He was arrested June 22nd, 2023.
Often state was, I think, around the first part of June.
All right. So he's charged with those two. Then thereafter, before he was arrested, a couple months later, he's charged with a
It was
murder.
a couple weeks.
This says April 18th.
Oh, I stand corrected.
April 18th, and then June 6th,
Oh.
which would be April, May, June. So I'm thinking about 6 weeks or 7 weeks later, he's accused of committing a murder. And in each of these three cases, he's classified as an habitual felon. He's finally arrested on
June 22nd.
He said that was for the murder. He was arrested
June 22nd. Well, finally arrested on something
Well,
on June 22nd of that year.
May 21st of 2023 on the tampering and the unlawful possession, and he bonded out on May 24th of 2023. And then he was
That is,
arrested.
you know what? Okay, I was curious about that because that's not in here anywhere in any of this. I swear it's not. I don't have a 23. So hold on. So he commits two crimes. On now, habitual felon. He gets arrested, puts himself out, and then goes right out and commits a murder.
Well, Your Honor, it's
Is that right?
alleged.
Is that right?
That's what he is alleged to have done. Yes.
Okay. The grand jury decided that he did that,
Interesting.
and apparently the authorities. Okay. What's his bond?
Have 1 million on the murder, 50,000 on the other two.
All right.
The
What
bond was
else?
so good on the other two.
Okay.
I'm sorry.
The bond was so good on the other two. They're still open bonds.
Okay. $1 million is the
What
main
else do
one
you
that
want
we're
to add?
concerned about.
What else do you want to add?
Well, Your Honor, we would ask that Mr. McCain, if the court were so kind to reduce his bond at all, from the current amount of $1 million to whatever it feels is reasonable, that he be ordered to wear a GPS tracking device, that there be some strict conditions setting the bond. There's been no evidence that he's not going to appear for future court dates. There
What
is,
about the evidence that he might be a danger to the community?
so there's, let me just address the evidence, Your Honor, in the murder case. So there is a lot of digital evidence involved in this case. It's going to take a lot of time to review. We may have to end up hiring our own forensic expert.
Okay, what's stopping
Anyway,
you
it's
from doing
going
that?
to, well, Your Honor, it's becoming it's a challenge to prepare a defense with Mr. McCain in jail. And I believe that he is entitled to a reasonable bond. He's innocent until proven guilty.
Unless proven guilty.
Unless proven guilty. But this offense is an alleged offense. He hasn't been convicted. He's been in jail for 3 years, and this is his first time appearing in court on a motion for a bond reduction. So I would
That's
ask the
terrible.
court to take
That's
that
a long delay.
consideration.
That's shameful. I
Yes,
think.
sir.
I don't know what happened on this, but I'm glad you're in the ball game because you move things along.
Thank you.
State.
Yeah,
Anything?
we think the bond is sufficient due to the fact he was out on a felony, commits another felony. And we do have a little bit more than what she's saying as far as evidence is concerned.
The court finds that the bond is reasonable under these circumstances. These are extraordinarily serious, severe circumstances. He was arrested, charged.
What do you think? Did the judge make the right decision, or should the bond have been reduced after such a long delay? Share your thoughts in the comments below. If you enjoy real courtroom moments, powerful legal breakdowns, and the most dramatic judge hearings, make sure to subscribe and turn on notifications so you never miss the next case.